This video on the Canadian political system focuses on the Constitution, of course, being the regulatory framework that governs how the different institutions and the different levels of government relate to each other, and of course also what types of rights that Canadian citizens have in relation to these bodies of governance. I will, in this video, talk about its composition, the role of the Supreme Court, and then I'm going to discuss how politics has revolved around the issues of the Constitution, this legislative framework for governance in Canada, and what the constitutional debates have primarily been about in Canadian politics. So first of all then, the Canadian Constitution is composed of several different aspects. First of all, a series of formal written documents, the first one directly concerning Canada being the British North America Act, the BNA Act of 1867. This act created the Dominion of Canada and laid out the basic rules and institutions of government. And in this text, it was stated that the governing of Canada should, for all intents and purposes, be done in accordance with the principles governing the United Kingdom. In essence, Canada was very much a copy of British governance at the time. Of course, since then, it has been amended numerous times to address changing political needs and reflect the unique Canadian experience. In that sense, it is its own legislative framework now. And in 1982, it was renamed as the Constitution Act. And that was a landmark moment because it terminated British authority over Canada. And it did so by adding an amendment formula to the Constitution, which allowed the Canadian government and the Canadian government, if we think about federal and provincial governments, to amend the constitution of the land without consulting the United Kingdom. Before 1982, any constitutional amendment had to be approved by the British government as well. It also included the Charter of Rights and Freedoms and added that to the Constitution. And that charter has been very important, particularly for the role of the Supreme Court. The post-charter era has been the subject of much constitutional debate since 1982, precisely because of how scholars discuss to what extent the charter might have changed the nature of the Supreme Court in this set of governing bodies. So those are the primary formal written documents. There are also British statutes and orders in council, particularly the Statute of Westminster. And finally, there are constitutional conventions. So not only did Canada import a series of statutes and the principle of governance from the United Kingdom, it also imported the tradition of having unwritten rules inform the constitutionalized practices of government. The United Kingdom is quite interesting and unique in that sense that it actually does not have a written constitution. Its constitution is unwritten. And Canada, while Canada does have at least partially a written constitution in the form of these documents and so on, it also has incorporated some of this practice of having unwritten rules that regulate the behavior. These are binding rules, possibly unenforceable by the courts, but they do matter for how government is done. And that's the basic composition of the Canadian Constitution. The Supreme Court being the body of governance that enforces and guards the Constitution and interprets it. The judicial decisions have influenced Canada's Constitution, particularly some decisions made before 1949 and after 1982. Now, this is a landmark year here. Some scholars say that the Charter of Rights and Freedoms have changed the nature of the Supreme Court in a fundamental way. Some would even say in a way that deviates from British traditions and thus from the Canadian traditions, in a way that is quite fundamental break from how the Supreme Court operated before 1982. They would argue that the Supreme Court has to be turned into an activist court that is much more politicized than it was before, because it suddenly has jurisdiction over a series of social issues that it didn't have before. Those social issues then, so argues the critics, should by right belong to Parliament to decide through democracy and the will of the majority. Others argue that there is, in fact, precedent for the Supreme Court acting in these areas, but regardless of who is right in this, it's clear that the Charter of Rights and Freedoms added aspects to the Constitution that weren't there before, and the debate about the effects of the Charter is not likely to go away anytime soon. It's noteworthy here, too, that in the US, the Supreme Court of the United States has judicial review and can strike down laws passed by the legislature, and that the practice in the United States is that when the Supreme Court has said its opinion on a matter, the debate ends. They strike it down, and that's it. In Canada, the Supreme Court also has a measure of judicial review, but the relationship towards the executive and Parliament is slightly different, in the sense that there tends to be more of a dialogue between the Supreme Court and the executive. A case comes before the Supreme Court, it issues a statement about the constitutionality of the law that is being scrutinized, and it could say that a law is not conforming to the Constitution, and they can strike this law down. But that doesn't necessarily end the political process. There is a dialogue there saying that the Supreme Court can be satisfied if certain terms are accepted. This is not to suggest that the Supreme Court and the executive is working together. The relationship is more described as a bit more of a back and forth between the legislating bodies in Canada than one would see in the United States. So an overview of the matters of constitutional change in Canada. I've divided it into several eras here, before 1960, and then the 70s and 80s, moving on to the Meech Lake Accord, Charlottetown Accord, and the situation post-Charlottetown. Before 1960, then, the major constitutional debates revolved around territorial integrity, autonomy from Britain, which of course had to do with this issue of the Canadian government not being able to make amendments to the Canadian Constitution, and that was this amending process, and the enshrinement of rights and freedoms in the Constitution, because originally in the BNA Act, there was very little about the rights of Canadian citizens. Indeed, before World War II, Canadians were British subjects, really, rather than Canadian citizens. Even the issue of Canadian citizenship is something that has arisen as a process of the development of Canadian governance. These debates were further shaped by what happened between provincial and federal governments, particularly the relationship between the federal government and Quebec. Quebec then went through the Quiet Revolution in the 60s, and the provincial government pressed very much the issue of Quebec's place in Canada. And this really fueled the debate on constitutional change. Quebec, of course, was taken into the British colonies by force in the 1700s, and the issue of Quebec's place in Canada and the Canadian Constitution had, so the provincial government of Quebec felt, not been adequately addressed since. Provincial demands for constitutional change, other provinces also started making demands for constitutional change, which resulted in the Victoria Charter of 1971, but Quebec rejected this package. And the Quebec referendum in 1980 initiated a new round of federal-provincial constitutional debates, and an agreement was eventually reached between the provinces and the federal government. So this new round then was fueled again by Quebec's concern about its place in the Confederation, but Quebec, ironically, was left out of the negotiations, so this issue was again not settled. Coming to the 70s and 80s, topics for constitutional debate then concerned still the amending formula, because that wasn't solved yet. The Charter of Rights, so this is again the issue of citizen rights and how they are addressed in the Constitution, but now in terms of a charter. The position of the Supreme Court, the issue of the Senate and the role of the Senate in the Canadian political system, language rights, which connects, of course, back to the issues voiced in the provincial government of Quebec, and the division of powers between federal and provincial governments. So 1982, that landmark moment with the Constitution Act, and that addressed the amending formula. So when the Queen signed that Constitution Act, Canada had a formula for amending the Canadian Constitution that did not require British assent or the assent of the government of the United Kingdom. It also included that Charter of Rights and Freedoms, but notably, Quebec refused to sign this. Since the other provinces accepted the Constitution, it came into effect as the Canadian Constitution, but because Quebec had refused to sign, those issues that the provincial government of Quebec had raised in the previous decades remained outstanding and unresolved. So we go on then to these rounds of attempting to amend the Canadian Constitution, the Meech Lake Accord and the Charlottetown Accord. These were attempts then to finalize these constitutional debates and address these outstanding concerns of Quebec. However, both failed. Meech Lake failed because, as people said at the time, it was 11 white men in suits making decisions for everyone else in Canada. And even though the federal government accepted it and almost all provincial governments ratified the Meech Lake Accord, when it came to the Manitoba legislature, it was defeated by one man, the deciding voice. It was a really close discussion in the Manitoba legislature, and it came down to one person, and he decided to not ratify the Meech Lake Accord because one large, very significant group of founding peoples of Canada had not been consulted during the Meech Lake round of negotiations, and that was, of course, the Indigenous Peoples of Canada. These peoples, the First Nations and the Indigenous Peoples of Canada, had never been consulted in building the Canadian governmental framework, never been asked to ratify any of the documents that have formed the Constitution of Canada, and therefore Meech Lake fell. Charlottetown was constructed again to now meet both the concerns of Quebec and of Indigenous peoples. Also, the process leading up to Charlottetown was much wider than Meech Lake. Not only provincial governments, but really participatory deliberative democracy with extensive citizen consultations all across the country, and including a national referendum to further ratify and legitimize the Charlottetown Accord. This was an attempt then to reach a compromise that could gain substantial popular legitimacy and turning directly to the people of Canada, precisely to avoid the situation of Meech Lake that was experienced as very unrepresentative for the Canadian people. However, the referendum failed, and after this extensive process, a compromise that could satisfy all the concerns of Canadians, regardless if they were Quebecois, Indigenous, or otherwise, had failed. We're now living in a post-Charlottetown era. There were a few more attempts to address the Constitution, but after Quebec's 1995 sovereignty referendum, any substantial talks of constitutional change have effectively ended, or at least been put on hold. But of course, that hasn't really solved any of the issues that have frustrated some quite significant groups within Canada. So the issues that were so driving for the governments, the provincial governments of Quebec throughout all of these decades have not been resolved. The issues that other groups, and particularly here Aboriginals, the Indigenous Peoples, the First Nations of Canada, are still outstanding. They have not been, these issues, these groups have been largely neglected in the constitutional changes of the 20th century. So the status quo clearly is also not satisfactory. It remains to be seen, given how hard it is to change the Canadian Constitution, how a compromise that will satisfy all parties can be reached, and who would want to reopen, given how difficult it has been in the past, who would want to reopen those debates. And that summarizes the main issues and political debates surrounding the Constitution and how the Constitution relates to the Canadian political system. I hope you found it useful.